child against them can often have personality disorders. They can also be very narcissistic. And again, those are things and triggers and red flags that will come up through expert testimony, through meeting with the child and the evaluators, being able to determine factors that are not in that child's best interest. And I know that especially when children are younger, there's a push to continue that continuity of the child-parent relationship. But particularly as they get older, you need to particularly listen, and even when they're younger, but there are definite factors that show concern for that child not necessarily being forced to go to a situation they're not comfortable with. And I think putting things into place and having it be supervisory in a manner with a responsible adult, a family member that the child has comfort with, while you're working through that and while you're exploring whether the relationship can be repaired is necessary. Thank you.
So this is one of the areas where I think Kayden's law is most important, because there's recent social science that reflects that when you have a parent who has raised an allegation of abuse, raising that allegation of abuse ends up coming back to bite the parent, because that becomes then the basis for an alienation claim by the other parent. And there was a study out of George Washington University that came out just last month, and I have copies for my colleagues or anyone who wants it, that talk about the negative outcomes for parents who raise abuse claims because then of counterclaims for alienation. And so there's increasing questions being raised about whether there is actually science to support the alienation. And so there's two things that I think that are important that come out of that Kayden's law can accomplish. One is in the section, one of the factors that judges are supposed to consider in custody is an alienation claim. Is a parent doing something to try to break up the bond between the child and the other parent? And part of what Kayden's law attempts to do is to build additional language into that to make sure that's not abused when there's a proper basis to say you shouldn't have a relationship with the kid because you're being abused, because you have violent tendencies. The other thing on this that I think that's important is the training that Kayden's law asks the Supreme Court to require, because it's that kind of training that would allow the judges to get up-to-date science like on these alienation claims. Thank you.
So at its core, we're back to what's in the best interest of the child, right? So, with adding 2 new judges to the bench here, where we have a very busy family court with a very busy civil court, hopefully will allow these judges, whoever they are, to really dig deep to find the truth, because that's what's in the best interest of the child, right? Without knowing exactly what is going on, how do we determine what's right for that child and that family? So whether it's a claim of sexual abuse or it's a counterclaim of alienation, we're back to figuring out what's in the best interest of that child and digging deep, listening to the evidence, taking the time to do it, testing it, pushing it. And if it turns out that there was a claim of sexual abuse that was raised incorrectly, then taking the time to do that will ameliorate that issue of when things are raised, you want to make sure it's truthful. If it was an actual claim of sexual abuse that was truthful and you dug deep enough to find out that that's the case, then that ameliorates the issue of any negative consequences for bringing forward that claim. So we're all coming right back to the same thing, best interest of the child, and keeping that in the forefront of our mind as we listen to all the evidence as it comes in.
My response here is really in lockstep with what Jordan said. First of all, alienation is absolutely an admissible factor because it's in our custody statute. So our judges have to consider alienation under the statute. With regard to the third question, is alienation a form of child abuse? And if so, is the risk of it more or less harmful to children than physical or sexual abuse? I'm back to my original response, which is there is no more important and paramount factor than the physical health and safety of a child in a custody case. So if there is alienation occurring, that is a much less important factor important, I think, in your legislation, that training for judges, because it requires, it doesn't require, but it suggests that judges should be subject to training to keep up with studies that are coming out. So I can assure you, as a judge, I would be participating in all of the training to make sure I'm abreast with the studies.
Thank you. So obviously alienation or alienation-like behaviors are admissible in a custody matter. And just 2 weeks ago, I was trying a custody case, and this issue occurred during the course of the trial. And in addition, the other side was pro se or unrepresented. So unlike what Jessica indicated earlier, there is an ability to cross-examine pro se clients or not clients, but pro se adversaries. And there is an ability to determine whether or not the truth is being told or not being told. And in this particular situation, this claim of alienation was brought up by the pro se litigant, and it was clear based on the cross-examination that that was just not happening and just was not true. So there are obviously situations that occur in court when people are unrepresented on the other side, where you do have the ability to determine what the truth is. As far as alienation being a form of child abuse, or more risk or less risk than physical or sexual abuse, I don't think there's anything that's more harmful to a child than sexual abuse and then physical abuse. So that would be my take on that issue. Thank you.
Just so you know, parental alienation syndrome is, it's not admissible. It does not reach the standards. It's flunked the test for admissibility repeatedly. And alienation has never been tested for admissibility. So there are some issues with it, even though it's commonly relied on. APA has rejected the use of PAS. The American Bar Association has rejected it, but it is relied on commonly. So something to think about, the admissibility of that. The next question is, what is the function of guardians, GALs, and custody evaluators? Where does the authority of each begin and end in custody decision making? Should hearsay be admitted into evidence? And if so, what type of hearsay? Give us examples, please.
The function of GALs and custody evaluators are in order to examine the child's, or to represent, I should say, the child's best interest when there is a difficulty that both parents are not seeing eye to eye. And those evaluators, they will be sent to an evaluation when parents are disagreeing